please the court. My name is Attorney Elaine Perinsky, and I represent the appellant, Mr. Stevie Walker. I presented a brief, thank you, that deals with two issues. The first one is the judge's jury instruction regarding mental impairment as it relates to extreme atrocity and cruelty. And the second issue has to deal with, and a number of subsets to that issue, has to deal with the defendant's statement. I'll talk about the first issue first and address up front that I know that the judge gave an instruction which was already approved by this court in the Slashta case, and sorry if I'm mispronouncing that name. But I think this is a case that best illustrates why that instruction is not sufficient. And I would ask the court to revisit that issue. As you know, this case...
Question about that, and I don't know the answer, but have you seen, I think they're been published, the new homicide instructions, that is the revisions to the 1999? You may not have.
I have not.
So I was interested in how, I should know this, but I don't, how the new ones address the issue that you're raising.
They don't address them the way you want.
Okay.
No, it says that you may consider the mental condition at the time, the defendants at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of consumption of alcohol or drugs, determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. Just the general reference rather than the factors that you propose.
Right. And I would argue that those aren't sufficient and that this court's proposed instruction in Gould, Rutkowski, and Rosenthal, which at least mention that there are factors and the jury should consider them in relation to the mental impairment. But I would suggest to the court that this case illustrates why those factors need to be mentioned in conjunction with the mental impairment, because this, as we all know, having read about it, this was a case that dealt with especially difficult facts relative to the nature of the crime, yet the jury struggled mightily, I would argue, in trying to understand how mental impairment related to extreme atrocity and cruelty. I think you see in the brief and in the transcripts that the jurors asked a number of questions regarding intent, malice, extreme atrocity and cruelty. How does intent relate to extreme atrocity and cruelty? The judge just restated her instructions and gave them an outline of the murder, theories of murder, without having anything on the outline related to the Cunin factors. The attorney in this case repeatedly objected to the instruction. I think he couched it in terms of intent, but I think one can look at it in terms of he was arguing that the court should not narrow the scope of the jury's inquiry as far as extreme atrocity and cruelty as it related to mental impairment and the factors. I'm not sure what the secret is. Why not tell the jury that the mental impairment relates to extreme atrocity and all of the factors? I think it would have aided this jury and perhaps would have led to a different outcome despite the horrible nature of this crime.
Why do you think it would have aided the jury? How would a different instruction have made a difference?
Because I think from the questions, one could infer that the jury was confused as to whether it related to malice and extreme atrocity and cruelty and not all of the factors. One could look at a number of blows, was it too excessive, and not even think that that relates to mental impairment at all. But I think it does, and I think the case law suggests that it relates to all of the factors. So I think if you just narrow it to just malice and the initial factor, then I think it's not helpful to the jury, which is why I think they came back with the second question. And again, I'm only inferring from the questions and not, I don't know for certain, but I think that's why they came back with the second question. Well, extreme atrocity in a reasonable person, is he a reasonable person? So I think this jury was a good example of the jury system.
Let me ask you, is this case any different than Schloska was, just in terms of the facts?
In terms of the facts, I'll have to go back on Slosher, but I mean, I think it's in line with those cases that are pretty horrendous as far as...
Same instruction.
Same instruction, which, as I state, this court approved in that case, but I think in this case, I'm not sure in the Slosher case if the jury was struggling as much as this jury with this case.
What year was that case? Yeah.
2012.
212.
Yes, I'm sorry, I should have known that right off
Last
the top
year.
of my head. Yes, it was last year, and I hope you don't think it's disrespectful of me to come back and say I'm asking you to revisit it, but I think
It's healthy.
I do think that the jury, we should listen to the jury in this case and say we need, and again, I don't know what the secret is. I don't know why not say what this court suggested in Gould, that it relates to all of the factors. Why not tell the jury that when this court proposed that? So I would suggest to the court that there was sufficient evidence of mental impairment in this case. There was the ingestion of cocaine and alcohol for a number of hours. There was one witness, Phyllis Calvi, who I would suggest lacked a bit of character, but she tried to downplay the amount of cocaine that was ingested, but Mr. Belcher said that Mr. Walker ingested cocaine a half an hour before the killing of Ms. Gotick. He was examined by both the doctor at Bridgewater and an independent doctor, found to have personality disorder with paranoid and schizoid features. There was some suggestion that someone with that disorder and the ingestion of cocaine could trigger a psychotic episode. It's unknown whether that happened because the defendant throughout the whole trial and prior to the trial maintained that he could not remember what had happened. But I would suggest to the court that we should aid the juries and tell them what we know. I mean, that it does relate to all of the factors. And I'm not sure there's any good reason to keep that from them.
Am I right that Gould itself, as I thought Schlachta kind of emphasizes, made it optional, even Gould did, made it optional to the judge whether to apply it to all of the factors?
To say that it applied to...
Yeah.
I believe, I can't remember specifically if Gould did, but Rosenthal, I think, did. But even in Rosenthal, they mentioned that it related to all of the factors, and that was sufficient. In Gould, it listed the factors. It was a proposed instruction, so I guess that puts it in the optional category. But it seems to be something that is needed to assist the juries. And I think that this case best illustrates it because of the horrendous nature of the facts and the fact that the jury struggled mightily. It would have been very easy for them not to do so, or it could have been very easy for them not to do so. So if there aren't any more questions, I'll go on to the next issue, which is the motion to suppress. I would suggest that the court based a lot of its decision on the fact that it didn't believe Mr. Walker in stating that he couldn't remember anything as far as when he left Phyllis Calvi's apartment until he found himself locked in a storage closet.
I'm sorry, you're saying that the judges,
It seemed from his decision that he just didn't believe Mr. Walker, that he had no memory. He felt that it was a self-serving statement.
well, that may be, but he made some pretty specific findings about why there was no violation of Miranda, why it was voluntary. et cetera,
Right,
et
he
cetera.
went to the age, the GED, the fact that he had a prior connection with the law.
And the conduct
A
of
number
the
of those
police.
factors. But I would suggest to the court that the circumstances really overrode all of those factors. This is a case that Mr. Walker arrived at the police station at 5:05. He was found sleeping on the bench. At 8:45, the judge did suppress a statement that was made in the lobby of the police station, correctly so. At 8:45, he was interviewed, taken and interviewed by the detectives, the homicide detectives. At 3:13, he wasn't formally charged until 3:13. From 5:05 to 10:30, he wasn't offered anything to drink or to eat. And this is a gentleman who was falling asleep, basically. He wasn't even offered a coffee. Right,
I thought they fed him
they fed him.
goldfish or
That was an hour and a half into the second interview with the detectives. So he arrived at 5:05, was with the local police, and then brought to the homicide unit. So it was during that interview that they offered him those goldfish and the
And
Oreo
he asked for a
cookies.
sandwich, which he
He asked for a
ultimately
sandwich.
brought but didn't eat most of, right?
Right, and later on they brought him the sandwich. But there's no indication that he was given anything to drink prior to that time. And I think the
which
trial
time?
attorney stressed that.
Prior to which time?
Prior to the 10:30, when he was offered something.
I couldn't tell from the, I didn't look at the transcript of the motion, although I know it's, I think, in your brief, but from the judge's decision, and there's quotations of the interchange about falling asleep, I inferred, and this is what I wanted to check, was that near the end of the interview, or was that all through, the falling asleep?
The trial attorney and the motion attorney, the same person, cited numerous places where he was falling asleep, and they said, wake up, wake up. I mean, he was asleep when they found him.
Right.
When the detectives went to get him, he was asleep in the cell. And I think a telling quote from him is, the recorder wasn't on when he actually signed the Miranda form. It wasn't turned on until after he signed the Miranda form. And they said, you signed the form and agreed that you'd like to make a statement with us. And his response was, maybe make a statement. I don't know what's going on right now. And there was no attempt to clarify that with him or to explain what's going on. In fact, he wasn't even notified that he was accused of the murder of Ms. Gotek throughout the whole interview. I mean, it became clear he was accused of a murder towards the end. But throughout the whole interview, I would suggest he seemed a bit dazed, bewildered, tired, unclear what was going on. When they asked him to sign the form to waive a prompt arraignment, he started to say, did I hurt Phyllis? Did I do something to Phyllis? And that was lasted a number of questions that he would ask, did I hurt Phyllis? And then he finally did sign the form. I think a significant thing which the judge sort of decided was inadvertent was the fact that he was not asked to sign, notified of his rights to a phone call. This is a defendant that was held incommunicado from 5 o'clock in the morning until he was formally charged at 3 o'clock. That is when he was given his notice,
Of his right to use the phone call, and he didn't make a phone call. He didn't exercise that right.
He did not exercise that right, but I'm not sure that that really has anything to do with the fact that he should have been given the right when he arrived at the police station at 5 o'clock in the morning.
Did the motion judge have before him anything other than the videotaped interview, the statements that were to be suppressed? Was there other evidence besides that?
There was the testimony of the police officers. They had the hearing on it.
They had the testimony of the police officers who were present at the interview itself?
Who were present, right, who conducted the interview. And like I say, they would say, wake up, you're trying to hide from us, make statements such as that. And when they had him sign the prompt arraignment, they said, you know how to read, don't you? But he had already signed the Miranda form. So I do think this judge's decision was driven by the fact that he just didn't believe that he...
What are we supposed to do about that? I mean, doesn't the judge get to make credibility determinations and assess the witness and all the rest of that?
Yes, but I would ask the court to look at the defendant's state, given the number of statements he made about his state, the fact that he was falling asleep, the fact that they kept having to prod him, the fact that he in the very beginning said, I don't know what's going on right now, when they asked him if he wanted to make a statement, and apply that. There's the one case, the Mankey case, which said if someone is held, it's a lengthy interrogation, and I would say that this was a lengthy interrogation, and in a lengthy incarceration, really from 5 o'clock in the morning up until 3 o'clock before he's charged.
Are you saying his will was overborne in some way, that he couldn't make a voluntary waiver?
I'm suggesting that based on what he said and how he was acting, that this gentleman was so exhausted, so confused, was locked in a closet for 36 hours. Prior to that was 2 days of cocaine and alcohol ingestion, that this gentleman was just... I'm not saying it was a situation where there was so much pressure on an average individual. It's the state that he arrived in when he arrived at the police station, and he asked, for something to eat. It was only within an hour and a half later that he got something to eat. So it was the state, the exhausted, confused, bewildered state that he was in.
Prior to the time he got something to eat, did he make any statements or do anything that were problematic for him?
As far as...
That you're seeking to suppress?
The attorney sought to suppress the whole statement.
No, I understand that, but you're saying, at some point he did get something to eat, he did get something to drink, he didn't really eat all that much, he didn't do very much with what he was given, but to the extent that you're saying that it was this very long period of time until he got anything to eat, is there anything that's before that 10:30 period that's particularly...
I'm not sure if he said at that point that prior to that point, he seemed to have said it all along that he couldn't remember what was going on. So I would suggest that perhaps for some people, and certainly for the judge, that was problematic because he took it as a self-serving statement. But I would suggest it was actually the opposite because the doctors were not able to conclude that he had a psychotic episode because he couldn't remember anything. So a self-serving statement would have been, oh, I flipped out. Or
I'll ask you a quick question before your time runs out.
Right.
It's about your claim about no phone call. The statute provides the opportunity when somebody's being brought in custody. Do you think that there is a difference or that the statute contemplates a different circumstance from this one or these circumstances where an individual is not brought into the station or ordered in, but brings himself into the station? Therefore, of course, has had an opportunity to think about it and make a phone call before he goes to the station. Maybe not this case, but like this case. Is there a difference? Should there be a difference? Isn't there a difference?
And
Doesn't the phone call contemplate someone who doesn't know he's going to be in the station without access necessarily to someone?
I guess I could see circumstances where there would be a difference. In this case, I don't, because of the condition. He walked.
Mental condition.
Right, the way he went, he arrived at the station, you know, it was, I mean, it almost as if he went to the station because he was just, I don't know where to go. At least there was a bench to sleep on. I mean,
Well, he
it was
actually said,
just-
"I'm turning myself in," but
Right, yeah,
otherwise
it was
I-
more motivated by
Wait,
desperation.
when he showed up at the police, he was eating something when he got there, wasn't he?
No, he had a candy wrapper in a Boston Globe. So if he had, one could, you know, it's a reasonable inference that at some point he ate that candy bar, but he had the wrapper.
Okay. Thank you. Your time is up.
Thank you very much.
Good morning, Your Honors, and may I please the Court. Sarah Montgomery on behalf of the Commonwealth. We are asking this Court to affirm the defendant's conviction and decline to exercise its discretion to reduce the jury's verdict or order a new trial in this case. If I may, I would like to first address the motion to suppress. The motion judge properly denied the motion to suppress on all grounds raised by the defendant. Regarding the defendant's Miranda waiver and the voluntariness of his statements, I'd like to make 2 points. First, there was no credible evidence, as the motion judge found, that the defendant was physically or mentally impaired when he walked into the police station, and likewise at the time of his interview. And second, the defendant demonstrated an ability to protect his interests throughout the interview. He provided a self-serving version of events, and he never confessed to the murder of Galina Kotik. Based on these factors and the totality of circumstances in this case, the motion judge properly found that the defendant had validly waived his Miranda rights and that his statements were voluntary.
What was so important about the statements if he never made any admissions?
The Commonwealth used the statement to prove or to show a conscious and deliberate decision that the defendant made to decide that he was going to claim that he had no memory of these 60 hours of his life, despite the fact that he had never forgotten a day in his life, as he told the detectives during the interview. He had never blacked out for any point in his life.
Had he ever used this kind of, had he used drugs to the extent that he used them that night along with alcohol over an extended period of time?
There was evidence that the defendant admitted during the statements that he used crack cocaine, he was an addict, but there was not evidence specifically of the fact or the period of time that he had used cocaine for, like in this instance. So the statements were important to show that the defendant sat in, or the reasonable inference could be drawn that he sat in this storage unit for 38 hours and contemplated a plan to turn himself in and tell the detectives that he was unable to remember these 60 hours of his life. I'd also suggest that, not undermining the Commonwealth's argument, that the statements could help the defendant, and it was for the jury to decide or to determine how they, the credibility of the statements at trial when they were played.
You mean could help in the sense that it supported the idea that he really had a psychological problem?
Yes, that was for the jury to determine. And there was a humane practice instruction given, I would like to point out.
Can I ask a question? Justice Link asked something in reference to videotape. Was there a videotape of this interview, or is this just an electronic audio tape?
It was just an audio tape. It was not.
We don't get to see how the defendant looked and appeared during the interview.
No, but I would suggest that the detectives did not say, "Please stay awake, Stevie." It was, "Keep your eyes open." And the motion judge never found that he fell asleep or that there was evidence of him falling asleep. It was that at certain points during the interview, he closed his eyes. And the motion judge was entitled to credit the detective's testimony. Detective Dugan specifically testified that the defendant closed his eyes when he was asked about the incident itself. But when the subject turned, or when the conversation turned to other subjects, the defendant's eyes were open and he was communicating, responsive, cooperative, as he was throughout the interview. And the motion judge was entitled to credit that testimony by Detective Dugan.
This is just, I understand no requirement, but does the Boston Police Department ever use videotape?
I believe that, I'm not sure if the Boston Police
these-
Department does. I believe that statements have been videotaped. There was,
Places, I just didn't know whether Boston does it.
I am not aware. I know that there was testimony regarding that at the motion to suppress. The defense counsel did ask Detective Dugan whether there was videotape equipment and if that was possible, and Detective Dugan said, no, they did not have the capacity to do so. Your Honors, I would also like to point out that the motion judge found that there was no intentional deprivation or delay in informing the defendant of his right to make a telephone call. The issue was raised after 3 days of testimony at the motion to suppress, and the officers at the district station were never questioned as to their whether they had asked the defendant or given the defendant the right to make a telephone call and whether that was an intentional deprivation of his statutory rights. Finally, turning to, if there are no further questions on the motion to suppress, just like to point out that the instruction given by the trial judge in this case was adequate. It told the jury to assess mental impairment as a factor as it relates to extreme atrocity and cruelty, as this court has upheld in Schlaka. The instruction mirrored that instruction in Schlaka, also the model jury instructions at the time, and also reflect the new model jury instruction, as Justice Duffley pointed out, which informs the jury to consider mental impairment, any credible evidence of mental impairment, on whether the Commonwealth has proved extreme atrocity and cruelty.
Granted, all that's true. But what do you say about the point that Ms. Perinsky makes, that in the context of this instruction, the mental impairment really could be understood by the jury, and the questions might suggest that it was, as relating to malice and not some of those things like the number of blows, et cetera, you know, the canine factors that don't, on their face, involve sort of intent questions?
Well, I would have 2 points. First, the judge adequately and clearly instructed the jury on all of the Cunene factors. She subsequently instructed the jury that they may consider mental impairment on malice, and that is correct. And then she instructed specifically, you may consider any credible evidence of mental impairment or voluntary consumption of drugs and or whether the defendant acted in a cruel or atrocious manner in causing the death of the deceased. And then she said, and that goes to extreme atrocity and cruelty. And this court looks at an instruction as on a whole, and as the judge told the jury to do so. And I think that in this case, the jury was properly instructed on mental impairment as it relates to extreme atrocity, cruelty, and malice. This court has said that there is no intent or knowledge requirement with respect or element with respect to extreme atrocity and cruelty. Mental impairment is merely a factor that the jury may consider, and the jury was properly instructed on that factor.
Just ask, that what you were just reading, was that the first time that the judge gave that instruction?
Yes.
And that actually was several pages from the Cunene factor instruction, right?
Yes.
Yes. So, and then she talks about intent, right? And it goes on several pages, and you don't get to connecting the mental impairment to the atrocity, a cruel and atrocious manner piece until here for the first time. It says, so again, deliberate premeditation. The malice is only intent to kill. Malice for purposes of extreme atrocity or cruelty or murder in the second degree includes all three definitions. You may, and this is what she says, you may consider any credible evidence of mental impairment or voluntary consumption of drugs and or whether defendant acted and/or whether the defendant acted in cruel or atrocious manner. That goes to extreme atrocity or cruelty. Now, that could be a typo. It's a little unclear, couldn't figure out what she was saying there. So then she says it again because there's a, later on, the judge says, oh, I think there was a cellular interruption. Let me say it again. Again, though, it's kind of couched in this whole malice and then goes into, and then a lot of reference to it rather than saying right after the Canine instruction, and you can consider mental impairment in connection with making the, finding atrocity and on that prong. So it's always kind of removed, and there's rarely never a definitive statement at any time that they're connected. You have to kind of, I had to parse through it, but I mean, listening to it is, I think there's a concern. You don't think there's a concern?
Well, first, I would suggest that the first time the instruction was given, not when the cell phone went off or during the jury's deliberations in response to their questions,
Right.
She did specifically say, you may consider mental impairment, the defendant's, and cruel, the defendant's ability to act with this cruel and atrocious behavior, and that goes to extreme atrocity and cruelty. So I would suggest that that is a connection. Also, in Schlaka, the same pattern occurred. The trial judge gave the extreme atrocity and cruelty instruction, then instructed on second-degree murder, and then instructed on mental impairment as it relates to extreme atrocity and cruelty. And the court upheld that instruction, same instruction that was given here, and also the instruction that mirrored the model jury instructions. And therefore, I would suggest that there is no error, and the jury is presumed to follow the instructions and was told and instructed to consider them on a whole. If your honors have no further questions, I would like to point out that this was a brutal and violent murder. The defendant consciously and deliberately entered Galina Kotik's apartment, stabbed her 26 times, covered her body with a rug, fled the apartment, and hid in a storage unit for 38 hours. On these facts, and given the fact that the defendant was given a fair trial, we are asking this court to decline to exercise any and all discretion under Chapter 278, Section 33E. Thank you.
Thank you, counsel.
All right. Hear ye,